Our next case is Paul FIORE DEFARIAS versus the City of Gloucester as amended, and another docket 24P1460. Mr. DeFarias, I know that the court officers spoke with you a little bit about how we're proceeding this morning. I just want to make sure you understand. Each side is permitted 15 minutes. There'll be a red, yellow, and green light in front of you. When your presentation is completed, please stay and have a seat. And then opposing counsel will make his presentation. You will not get a decision today. We take the matter under advisement, and you'll get that decision usually by email. Do you have any questions about the process?
No, Your Honor.
Okay, so you may take the microphone right there. Please try and keep your voice nice and loud. And as you probably have seen this morning, we will likely interrupt you with questions.
Good morning, and may it please the court. My name is Paul DeFarias, and I am representing myself regarding the appealing brought forward from the Suffolk Superior Court and the Civil Service Commission regarding bypass by the City of Gloucester in April of 2022. Today, I'm requesting the court reverse the Commission and lower court's decision and award any other relief deemed appropriate in regards to legal costs and potentially a new trial by jury that allows for conclusive testimony and evidentiary records without summary judgment. The appropriate standards that apply come from civil service law, specifically reasonable justification and the basic merit principles. I will be arguing how the city violated these laws and created an unfair advantage through the selection process. The core mission of the Massachusetts civil service law is to enforce the basic merit principles, which are defined in part as follows: recruiting, selecting, and advancing of employees on the basis of their relative ability, knowledge, and skills, including open consideration of qualified applicants for initial appointment. Additionally, the basic merit principles must assure that fair treatment for all applicants is across the board, including applicants and employees in all aspects of personnel administration. Also, the basic merit principles assure that all employees are protected against coercion for political purposes and are protected from arbitrary and capricious actions. The city bypassed me, citing various alleged employment issues, but refused to provide any documentation that support these alleged issues. Additionally, they stated I was not bypassed and was offered to be considered for employment. They told me in my prior representation that they were told information that sparked concerns. However, it's if this information they were told was so concerning, it is questionable why I was being offered employment during my interview, as well as received a settlement offer to drop the case in exchange for that employment. These conspicuous actions caused great confusion, and being offered employment, not once but twice, would deem the bypass as moot. The Civil Service Commission hears and decides appeals on public employees under the protection of the civil service laws, ensuring all employment decisions are based on relative ability, knowledge, and skills of the applicant, and ensure that all applicants and individuals receive fair and impartial treatment. During the Commission's hearing, it was discovered that the City of Gloucester investigators entirely discarded all of the positive remarks, providing a conflicting, biased report to the decision maker. The city's failure to conduct more than a brief telephone inquiry, made no attempt to obtain any of my records or incident reports from my prior employers, and a cherry-picked, negatively biased investigation report that was provided to the chief, who was the decision maker, gave him unable to fairly review myself fully as an applicant.
Could I ask you, if the chief had all of the information, all of the good and all of the bad, would there still be a basis to not hire you?
I don't believe the chief had a full review.
You're arguing the procedure was unfair, and I completely understand that, and I certainly have questions for the city about the procedure. But I'm trying to sort of extrapolate it out. If they had the entire universe of information that you say they should have had and the negative stuff, could they justify the decision to bypass you?
On 2 points, Your Honor. I don't believe that the chief had a full review of myself and the applicant, because the city's investigators withheld all of the positive information favorable to myself as the applicant. And under civil service law with the basic merit principles, the appointing authority, which would be the city, but specifically the decision maker being the chief of the fire department, was unable to fairly review all aspects in regards to myself as a candidate. Secondly, the favorable information was not only withheld, the negative information in question was never confirmed with any of my employers. The negative allegations in question all come from the detective's own chicken scratch notes that were not followed up with. There's nothing that proves them that they're actually true. And during the commission's hearing, I provided all of my employee files so that way the city, as well as not the judge, but the
commissioner.
The commissioner, thank you, I apologize. But the commissioner would have a full, open, fair review because he has those employee files in front of him.
So just to follow up on the chief's question, the commission, during the commission review, so moving on now from the initial review by the city, do you agree that the commission had in front of it the good and the bad and a complete record?
I don't believe so, Your Honor, because upon the days leading up to the commission, we asked the city multiple times through my prior counsel for any and all records. I also signed a release to the city during my application process that I would be entitled to all such records. And all we got was a 2-page report from City of Gloucester Lieutenant Detective Williams, which had some bullet points that was about a page and a half to 2 pages. And it was all conflicting and kind of toppled over itself. I believe one of the statements, I'm going to rinse off verbatim, it says I was let go or possibly resigned from one employer, and when Lieutenant Williams was asked on that during testimony, he said he didn't know which it was. So I don't believe that, going back to your initial question, that the commission had all the facts, considering at the commission the detective said that there was an investigation file that had 102 pages that we asked for, myself and my prior representation, that we did not get. So I believe knowing that, having that ahead of time, would have had a better argument, and with the commission having a more full grasp than knowing that this document exists, we not being able to have it to get a full rounded picture where all of my employers in question that gave supposedly negative statements about me recommended me for the job and said there was nothing that would disqualify me as an applicant.
Dispute the judge's finding that as to Cataldo and Beauport, that you were terminated?
I'm sorry, could you repeat the question?
Do you dispute the judge's finding that you were terminated by Cataldo and terminated by Beauport?
I don't dispute the one at Cataldo. I was terminated at Cataldo. I provided the chief a written explanation during my application process and interview, as well as I gave a copy of my termination notice during the commission hearing. I do dispute the fact that I was terminated at Beauport because Lieutenant Williams went to the owner, and the owner I really had no interaction with. I know that the events following Beauport was a thing of indecent exposure, which I testified to at the hearing, and I dispute that because it's not accurate and that they're not putting that in writing. So
the judge said that the Beauport termination was due to repeated clinical errors and personality conflicts.
I'm sorry, are you finished, Sharon? I didn't mind.
Yes. Do you dispute that?
I do dispute that only because, one, none of it exists, and secondly, anything that's said that was in those chicken scratch notes by civil service law needs to be proved by a preponderance of evidence, and I don't feel, I'm not an attorney, but I don't feel in my well-minded opinion that chicken scratch notes constitutes for fact and truth. And considering that I have an email from Beauport that says that they can't provide anything and that they can't say that, I respectfully say that it's hearsay.
I know what, when you say you have an email, is that in this record here?
It is in the one of the appendices.
Okay.
I can get that information for you.
There is an issue about the appendix, right? You filed a motion. You want to put in other materials, and opposing counsel has asked us to strike that. Is that affidavit in what you're trying to file as a supplemental, or was that in the record below? Because we can only consider what happened below.
Okay.
So do you know whether?
I don't believe that email is in the first volume.
It's in volume 3. If you're talking about the email, I think you're talking about, it's volume 3, page 49, from Gianni Riccio.
Yes, that sounds correct, Your Honor. I know that the Superior Court was limited to documentation for what they could review. That
as
is why.
Are we? Just so you understand procedure, as are we.
Oh, okay.
We can't take anything that the Superior Court judge didn't see, and he can't take anything that the Civil Service Commission didn't consider.
Right.
I just want to make sure you understand that.
I understand that, ma'am.
But do you agree that you left Beauport like very quickly, following a conflict with a supervisor?
Considering the conflict was that the supervisor asked me to commit indecent exposure at a school. I emailed my general manager right away, and I respectfully asked him to resign. I asked him over the phone if he wanted a letter of resignation, and he said, "Paul, don't worry about it. We're all set." And he provided me a letter of recommendation because I told him I would be more than happy to stay my 2 weeks.
And is that in the record too?
It should be, Your Honor, but if it's not, it's mentioned in my brief. I think it's at volume 3, page 45. I'm going to mispronounce the name because my Portuguese is not so good, but Joe Laranjeira?
Yes, ma'am. But additionally, excuse me. So the commission's role is to determine if the appointing authority has shown by a preponderance of evidence that it has reasonable justification, for the bypass and an impartial and reasonably thorough review, which reasonably justification means done upon adequate reasons sufficiently supported by credible evidence. The city's withholding of crucial evidence being the investigation file, as well as not completing a full, proper, thorough investigation sparks concerns.
So we understand that there were problems with the investigation, but the question is, once you're at the commission, did they have everything in front of them?
At the commission's hearing, no, ma'am.
You think no? Okay.
So the commission actually cited specifically from their decision, and I quote, "It is perplexing why the city's investigators did not request any personnel files from any employer. It is also of real concern that prior to the evidentiary hearing, the appointing authority failed to produce crucial evidence, namely the notes and checklists used by the background investigators."
Right, but that's why I'm asking this question, because you say you provided all of your employee files, and we know they have the chicken scratch notes that you're referring to. They had that. So that's what I'm trying to figure out. What did they not have?
They didn't have the investigation file that had all the predominant positives that were left out from the commission as well as the decision maker.
Didn't that eventually get produced?
I'm sorry?
Didn't that eventually get produced?
It did, ma'am, but by the time that the city stated that I had opportunities to recall witnesses in regards to continuing the hearing, and unfortunately with this I had run into over $20,000 with my legal representation, so my window for that ended up coming to a close, and I tried to wing it myself. So going back to your original question, they did get released, but I didn't have enough time to follow up with that, and that's why I took it to the superior level, which had limited documentation. Following the commission's decision, there was 2 separate reviews. If you Google my name, they'll come up. One of them is by the Massachusetts Civil Service reports, and the other one is from the Massachusetts Fire and Police Chiefs reports. they agree that the entire process was flawed to begin with, that because the city withheld the positive information from the chief and they refused to provide me the notes and the checklist that they did upon their investigation, that it was flawed. And the question for argument is, does a flawed process and procedure and withholding of evidence and positive information favorable to myself as an applicant justify to bypass me when, one, their investigation file chicken scratch notes contradict their own bypass, and everything I have provided in regards to my employee records shows that that bypass is not accurate. So if it's accurate and it's 100% true, absolutely, I'll take the bypass, I'll take the hit. But it's not, and that's why I'm hoping I'm here today to convince the panel otherwise, that this information is, I believe, twisted. And I hope that in order to correct this appeal as proper and true, that it needs correction. So therefore, I pray this court will reverse the decision made by the lower court.
Thank you very much.
Thank you.
You did a good job arguing for yourself.
Mr. DeFilippis?
Good morning, Chief Justice and panel. May it please the Court. My name is Rocco DeFilippis. I'm the Assistant General Counsel for the City of Gloucester, arguing on behalf of the city as appellee. The Court is familiar with the standard of review on a civil...
But I have to shoot the messenger, and
Sure.
I know it's not you. This investigation, it's embarrassing. I don't know how they let Williams continue to do this job. I mean, there may still be a basis to bypass, but it's a terrible investigation.
And, Your Honor, I think that's why the Commission looked to Sherman to apply the law to what to do in this situation. And I think that the SJC advised that when you have these procedural flaws, the court on review is engaging in careful scrutiny of the record to determine the motive of the appointing authority. And I think it's not...
But, I mean, who cares what the motive is if somebody has basically cut you off at the knees? I don't care why they cut me off at the knees. Who cares whether the detective had malice or was lazy? He only passed... I mean, basically the detective became the decision maker and only relied on negative information.
I think that the record shows that the reason why the focus on the motive is so important in Sherman is because that is what allows the reviewing court to then carefully determine when you, if the record is complete enough for review of whether the decision was nonetheless reasonably justified. And so what we have here are the findings of the Commission that, yes, this record is complete enough for the Commission to engage in its statutory obligation to review this record to determine whether the fundamental principles that the statute protects have been honored in this bypass. And the record itself has many opportunities that show that a review on a substantial evidence basis is going to show all their findings, their key findings, are supported by this record.
Well, let's talk about the Linfield fire for a minute, and this is at our 0106. So Williams says that DeFarias was, quote, let go or possibly resigned. We have his resignation letter. What is let go to me suggests something maybe not so positive. Resigned could be any number of reasons. We have a letter that says he resigned. Williams couldn't figure that out?
I think that the magistrate was very careful in his fact-finding regarding this particular issue because, first, I would note that it was Detective Treffy who spoke with Linfield. And I would like to just note in my brief, I think Mr. DeFarias pointed this out in his reply, that I switched the names of the Linfield personnel. I referred to Captain Alexander as Captain Davis. I apologize about that. That is a mistake.
Thank you.
But the citation to the record is those portions of either the testimony or the documents that show that Detective Treffy spoke to Captain Alexander. And I think the important thing, again here, when that first and fundamental finding that there is no evidence of improper motive is considered, the reason why this is relevant is because the magistrate makes a credibility determination. He finds that the detectives testified credibly. And that's important because a credibility decision that's squarely within the realm of the magistrate, and for the commission, it's not available on review.
I agree that that the credibility and motive are within the ambit of those decision makers' purview. That's a horrible sentence, but you know what I'm trying to say. But that's not it, right? I mean, Sherman also was careful to say, and this is in a footnote, but the decision may not be arbitrary. So it's not only a showing of improper motive or bias that would potentially undermine a decision, in this case, the police department's recommendation. It's also a showing of arbitrariness. And isn't it arbitrary to look at only a tiny section of the history here, of Mr. DeFarias' employment history, and based on only that little slice, part of which is inaccurate, to make a recommendation?
Well, I think that, again, the commission's decision is very careful to parse what is disputed and what is undisputed, and then relying on that undisputed evidence to make its review. And so in this situation, is it credible testimony that when the detective calls the fire department and speaks to a reference that they don't have the file in front of them, they can't quite remember whether he resigned or he was let go, they write that down in their notes. But the most important piece of that conversation, of that reference check, which is the law is well established that the appointing authority can rely on anecdotal evidence from references regarding an employee's qualifications and experience at that employee. Captain Alexander, when asked, well, would you offer employment to Mr. DeFarias? The answer is no. And it's that particular fact that the chief discussed during his testimony, and that the detectives themselves keyed in on. And I think an important fact that ties the fact-finding together is that the chief testified on 2 separate occasions that the detectives that he relies on to conduct these background investigations are familiar with the fire department's hiring standards. And so there is several lines of questioning in the hearing regarding, well, if you had known this, or
this
if you had...
takes me back to the same question about who's the decision maker, because the way this process got set up, the detectives were the decision maker, and that's not okay. Instead of gathering information and providing it, they became more than a filter. They just made a decision and then gave only the evidence to support that decision. Why is that okay?
Well, I think for two things. First, the commission is able on its de novo review to look at the whole record, which I submit to this court that this court has everything that the commission saw in terms of the discovery issue with what records were provided. Everything was able to be submitted. So the court has the full sight the commission has a full view of the record. And when they are looking at their determinations, this is where the court is giving the deference to the agency for its specialized experience.
But this is the problem is that once you've got this taint, how do you get rid of the taint? If the decision had gone his way, we'd be in this same situation that, there's enough here in this record for someone to go to pick through either way. Do you agree it was just plain wrong to state that he had been terminated from a prior employer for attendance issues? That was just wrong, right?
So on this very issue, I think, again, that the initial prong in Sherman, the thrust of Sherman is the court is carefully scrutinizing the motive. The testimony
but I just want to get a clear answer. That was wrong. He was not terminated for attendance issues, right?
No, he was not. And the commission, in their findings, that's one of their findings, and it's supported by substantial evidence in the record.
Is there a record site to support the idea that Beauport terminated him?
This is, I think, the important part of the commission's decision is where they're making their credibility determinations because, as the court is aware, the commission is allowed to fairly choose between 2 competing alternatives, and as long as their decision is reasonably supported by evidence in the record, the court's going to uphold it. And so here, the omission of the departure from Beauport is focused on by nearly every decision maker in this record, especially in the commission. That is what they used to make their credibility determination on whether or not to credit the testimony of the detective regarding his conversation with the business owner. The record has substantial evidence that the Gloucester Police is familiar with both of the Cataldo and the Beauport because they frequently provide candidates for the fire department. And so the record shows that that finding, that credibility determination, that the owner's recollection is what the commission zeroed in on. I think it's an important finding because if you look at a case like the decision like St. Denis, where there, even the commission applying Sherman, they still find that, okay, this record is sufficient for us to make a reasonable justification finding. And in that situation, the procedure that they were so concerned about was that the applicant was never even spoken to at all. They submitted an...
What do they do, though? Because there's a couple of places, and this is at volume 345, where we have this letter from the general manager from Beauport that says, I have the pleasant opportunity to work with him, and he would recommend him without any doubt or reservations. What do we do with that?
Well, I think the important thing to note is that, yes, there is a lot of evidence about positive information that is received that the appellant is able to put in for the commission's consideration at the hearing. However, none of it actually contradicts the key findings that the commission made regarding the departure from the termination at Cataldo, and then this credibility determination that they make this fact finding regarding the circumstances of the departure from Beauport. And then it looks at essentially what do those two events suggest. And they talk about this multiple dovetailing of reports that raise kind of similar concerns that are reasonable justifications for a bypass, especially given the nature of the public safety position of a firefighter regarding confrontation with supervisors. The review says...
But that's though when I get concerned, because I look at 47, and the commission seems to, I think, focus on that he needs to improve on accepting advice from others. Right, and they can rely on that, but they ignore the next part, or tell me they don't. Maybe I'm wrong. I welcome that because I will accept advice from others. That he's no better or worse than anyone else. That changes the whole tenor.
I think that the important distinction here is: does an appointing authority have to defer to a positive reference, and say, okay, if this is what your information is, then we have to accept that? I think no. I think the commission is obligated to give deference to the appointing authority's policy. One of the findings that the commission made, a finding that is supported by...
That's the whole problem with this case and why it's unsatisfying. We can't look at any finding that the city let the detectives make. All we can do, or all the commission can do, is go back and pick through the whole thing and say, well, now that you've botched this, is there enough for us to say, okay, this is awful, but, it's close enough? Or do we say, you know what, you really didn't give him a fair consideration, go give him a fair consideration. And you can't just take the first sentence, which is the needs to improve, when the next sentence is he's no better or worse than anybody else.
I can appreciate the concern the Justice is raising, but at the end of the day, on review of the Commission's decision, this is essentially what the Commission exists for, is to wade into these factual disputes, to weigh the evidence that they have before them, to make the credibility determinations based on the testimony. And when they make factual findings based on what was presented at the hearing, the courts on review are looking at the record to see, well, these findings that you made, are they supported by substantial evidence in the record? And I think that in this case, there's really nothing you can point to in the record that fundamentally undermines the most important findings that they make, namely that there's absolutely no evidence of improper motive, which allows the court to apply the test in Sherman.
Right, but I'm still going to go back to, if you know motive at all, why do I care if you've cut me off? I guess I'm not hearing the city say, we could have done better and we're going to do better. I'm hearing the city say, this is what we're doing to everybody, and we're going to let these two detectives do a shoddy job and make the decision that's not theirs to make, and that's the way it's going to be. And I want to understand why the commission should go along with that, and I'm wanting to understand why we should go along with that. Would you want to be reviewed using this process?
What I think the important thing here is
your credibility is at stake here. Would you want to have these two detectives pass on only negative information about you and not get your personnel file and not pass on anything positive about you?
I think the two things that are important from the record are the detective's credible testimony and the HR director's testimony, where they say that they discussed the detective's findings. That is in the record. That testimony was credited, and that is in the context of them getting ready to prepare the letter. And so when you and the other thing is that the chief credibly testified that the detectives are familiar with the department standards. And I think, and I don't want to wade into the weeds on Beverly, because I know that the SJC has given it some type of review. It's to me, it's still good law. I think it's this court very carefully dealt with the issue that was present there, which is, when we have a dispute about misconduct, to what extent does the appointing authority have to go to get to the bottom of the misconduct when we're talking about a third-party situation in an employment history? And as the SJC pointed out in 2019 in the Boston police case, there is no different standard. It's preponderance of the evidence. And to the extent that Beverly suggests it's different, that, well, that's a mistake. You're not reading it correctly. But at the end of the day, the logic of Beverly holds clear, and the test in Sherman inoculates this process. When there are mistakes, there are procedural mistakes. I don't think I'm standing here for the city of Gloucester and saying, well, the commission's wrong, we did everything correctly. What I'm saying is the commission did not commit an error of law. The commission identified the issues, it correctly identified the test, it applied the test correctly, and the record is replete with evidence that can support those findings. And so on review, that is what this court is looking at, are these findings supported by substantial evidence? Not would we have decided this differently.
So your time has expired. I do want to say one thing, and the department often hears me say this to them. So I'm going to say what I say to them to you, which is, I have no idea how this case is going to come out. But as the lawyer to the city of Gloucester, I would ask you to let the city know the concerns we have about how this investigation was conducted, how this case proceeded, and they need to do better, regardless of the outcome of this case.
Certainly.
Thank you. The case is under advisement. Thank you all.
Thank you.
And Mr. DeFarias, I know